first featured address, the Internet Law and Society, and the topic will be Evolving Impact of Technology on the Judiciary. The speaker is the Honorable Justice Adrian Saunders, President of the Caribbean Court of Justice. I can almost get away with saying he needs no introduction because everybody knows Adrian. But that would be a bit too much. Essentially, as stated in the CCJ's website, he was a graduate of the Hugh Law School in Trinidad and Tobago in 1977. He joined the Eastern Caribbean Supreme Court as a High Court judge in 1996 after 19 years of private practice. On May 1st, 2003, he was appointed to the Eastern Caribbean Supreme Court's Court of Appeal, and he served as acting Chief Justice between 2004 and 2005. Thereafter, he was among the first cohort of judges to join the CCJ bench in 2005. He served dutifully and faithfully and was then elevated to the presidency on July 4th, 2018. It gives me great pleasure in asking Justice Saunders to make his presentation.
Thank you very much, Justice Barrow, Dennis, and a pleasant good morning to everyone. It is a tremendous privilege and pleasure to be afforded the opportunity to make this brief keynote address, because I think forums such as these fulfill one of the important goals that was envisioned for APEX when it was originally conceived. From the start, it was never considered sufficient for the company to be a mere provider of technology to justice institutions. APEX has always considered itself as also having, among a range of other responsibilities, an obligation to promote and facilitate a continuing dialogue between ICT experts on the one hand and law and justice officials on the other. And so here we are today. There is so much to discuss. In each of these two spheres, justice and ICT, there are tremendous changes occurring in the world as we speak. These changes mirror the dynamic trends and developments we are witnessing in every facet of life. The challenge for us who inhabit the sphere of justice is severalfold. How do we keep abreast of technological developments and their increasing influence on our societies? How do we harness and apply that which is useful in order to enhance the administration of justice and the rule of law? What steps do we take in the face of contemporary expectations of service delivery to promote public trust and confidence in the courts? Forums like these are important precisely to assist us in answering these critical questions. While it is true that had the pandemic not intervened, it would still have been necessary to hold this kind of dialogue, there's no denying that COVID-19 has brought several things into clearer relief. Firstly, it has reminded us that we inhabit a VUCA environment. That is a space that is volatile, uncertain, complex, ambiguous. Secondly, it has rendered more urgent, more serious, more imperative the need for courts to transform themselves into agile institutions. And thirdly, relatedly, it has confirmed that with the necessary motivation, courts can indeed utilize digital technology rapidly to at least try to adapt. I recently read a report from Pluralsight, this is a technology workforce development company, in which it was stated that the top 3 trends impacting technology teams in 2021 were A, workforce transformation, B, tech modernization, and C, digital acceleration. This assessment was, I believe, principally aimed at private sector technology teams. But the priorities that were identified all resonated with me. I thought that they uncannily spoke to the kind of imperatives that have been confronting courts even before the onset of the pandemic. Let us briefly reflect on each of these in turn. Workforce transformation. For some time now, court staff and judges alike have been and are being asked to do more with fewer and fewer resources. Staff are also being asked to do new things. I can speak from personal experience, as this has particularly been the case at my court. Over the last year or so, the CCJ has spent a considerable amount of time and effort in honing our approach to the implementation of our strategic agenda, in fleshing out our court excellence and risk management frameworks, and in reviewing the design of our organizational structure. Some of this is unfamiliar stuff for most of us. And so we have had to invest heavily in workforce issues as we grapple with them. But we are convinced that we are on the right track. And with each passing quarter, we are getting better at what we are about. It has required and will continue to require significant training and upskilling and cultural change to succeed in our objectives. But that is what workforce transformation is all about. A judiciary has to be committed to a culture of continuous learning. The management guru, Peter Drucker, famously declared that culture eats strategy for breakfast. Culture is how an organization thinks and acts. The values, customs, beliefs, habits, and symbolic practices that in our judiciaries we live and breathe every day. The point is that these will always dominate and prevail over whatever strategy we develop or seek to implement. Bevel Wooden has rightly commented that, and I quote, an organizational culture that is constantly curious, highly sensitive to social shifts, and unwavering in its commitment to innovating and evolving is what is required to navigate life in the digital age, unquote. For our courts, this requires investment in training, learning, and upskilling. Tech modernization, the second trend mentioned by Pluralsight. Caribbean judiciaries have been struggling with the imperative of modernization over the last 2 decades or so. The need is still very much there. In May of last year, the CCJ, together with the Caribbean Association of Judicial Officers, CAJO, collaborated with the Academy for Law, the Jurist Project, and APEX, and convened an online forum to discuss judiciary needs, judiciary challenges, judiciary best practices, particularly in light of the global pandemic. The event was attended by 115 participants from across the entire region. And at the conclusion of the conference, several issues were identified. The first and paramount one was insufficient technology to adapt properly to the challenges posed by COVID. Law and justice institutions encountered technological challenges that included lack of proper electronic and case management systems, insufficient access to virtual hearing platforms, poor or inadequate internet connections, lack of online systems for payment of fees, lack of systems for electronic archiving, document storage, and document exchange, problems in the standardization and compatibility of software and programs between and among the courts, state agencies, and the bar, lack of support and training for the issue of technology, uncertainty as to what technology is appropriate for use by courts. What is interesting about the items that I've culled from a much longer list is that none of the above reflects a need that suddenly arose with COVID or that will disappear when COVID eventually does. Each and every one of them reflects a basic imperative of modernization. And layered atop all of them, of course, is cybersecurity and data protection. The more we invest in tech modernization, the greater the need to secure that investment and its fruits. It goes without saying that as a matter of urgency, every judiciary must engage in tech modernization. Even though mere modernization, as we shall see, is insufficient to address many of our fundamental weaknesses. Digital acceleration, the third top trend identified by Pluralsight. The potential of digitalization increases at such a rapid pace that any innovation we implement today will be stale, if not entirely obsolete in a few years' time. What this means is that firstly, failure to innovate today doesn't leave us standing still. It carries us backwards. Once you're on the digital treadmill, you get off, if you can, at your own peril. Secondly, once aboard, you must adopt and practice over and over again the four-step cycle. Assess, analyze, implement, evaluate. The sad reality is that we live in a world where more people have access to the internet than they have access to justice. According to the OECD, only 46% of the world's population live under the protection of the law. On the other hand, the International Telecommunications Unit stated in its report in 2018 that more than 1/2 of the world's population is now online. At the end of 2018, 3.9 billion people were using the internet. Now, these are stats that are irreversible, fast-growing, awe-inspiring. Information today is globalized, pervasive, and extremely influential. The influence of the internet and social media is, unfortunately, not always positive. An historical fact. Smallpox existed in the world for some 3,000 years. It was a terrible and lethal disease. On average, 3 out of every 10 people who were infected, they died from it. And those who survived usually had scars, which were sometimes severe. The World Health Organization commenced an intensified smallpox eradication program in 1967. 13 years later, on May 8, 1980, the 33rd World Health Assembly declared the world free of this deadly disease. This phenomenal feat occurred largely through mass vaccination. Question is this: would smallpox have been eradicated if social media existed between 1967 and 1980? I doubt it. The point is that, quote, customers are naturally captured in these global trends that show the profound reach and influence, positive and negative, of the internet and internet-based platforms. What expectations would the population reasonably have of the operations of the courts and other public institutions when, for example, they are accustomed to the instantaneity of internet solutions? How do we as judicial institutions maintain the public's trust and confidence in the courts in the face of the tremendous information, misinformation, and cynical disinformation that is so easily accessed on the internet? Unfortunately, courts are traditionally slow to respond to these kinds of challenges. Indeed, the administration of justice naturally tends towards conservatism. Predictability and certainty are attributes which, with good reason, are highly valued. Moreover, the common law method that we in these parts have inherited is one that is essentially backward-looking. We are trained not to depart too readily from following precedents established in the past. we illuminate the way forward by looking backwards. And all of this produces a culture, ingrained habits of thought that often results in slowness and even resistance to embrace novelty. Where change is concerned, incrementalism is valued, not so much radical transformation. A recent case from the Turks and Caicos Islands demonstrated the tension law and justice can have with novelty. There's a criminal case in that country. The former chief minister and others were in the dock. A Jamaican judge was recruited to preside over the case. Trial was proceeding in the TCI for quite some time before COVID struck. Travel was disrupted. The Jamaican judge returned to his native land, and the TCI governor in 2020 enacted the Emergency Powers COVID-19 Court Proceedings Regulations. Among other things, the regulations made provision for court cases to be conducted via remote hearings. Courts all over the world, of course, adopted similar regulations given the pandemic. Clear idea was to enable the judge to continue the trial while he was in Jamaica using one of the well-known remote platforms. The defendants complained that the regulations were unlawful to the extent that they purported to create a courtroom outside the jurisdiction of the TCI. According to the lawyer for the defendants, where the judge is, there the court is. So that if the judge was in Jamaica, the court was in Jamaica, and it was impermissible and unconstitutional for a court located in Jamaica to try a TCI case. A TCI judge actually accepted those submissions and declared the particular regulation unlawful. Fortunately, and not surprisingly, both the Court of Appeal and the Privy Council came to a different view, and they held that the regulation had properly deemed the place where the judge sat physically to be part of the courtroom in the TCI, and that notwithstanding the physical location of the judge, the latter's judicial power and authority were being exercised in the TCI in keeping with the TCI constitution and laws. This, I think, was a sensible and just result. But the case does cause inquiring minds to ponder questions relating to cloud technology. Which country has jurisdiction over the data one's judiciary stores on the cloud? What are the regulations in that country governing access to that data? Who owns that data? Can the host country treat with that data in a manner contrary to the wishes of the owner? The case also causes us to reflect on this concept of the courtroom. Many judges, lawyers, litigants, and other stakeholders who are fondly attached to the awe-inspiring majesty of the courtroom exist. The flowing robes of the judges and counsel, the arcane and high-flown vocabulary they alone use, the awesomeness and mystique that inhabits this sacred sanctum, all combine to produce an aura that we readily identify with the dispensation of justice. Richard Susskind, an English professor, was the first to separate the function of a court from this lofty image with which we associate the dispensation of justice. Susskind is the world's most cited author on the future of legal services. He has been advocating this separation for decades now. He does so not because he is repulsed or alienated by the traditional image, but for the more prosaic reason that really, a court is not a place. It is a service. For decades now, he has been advocating for online courts and demonstrating how court processes can and will be transformed by technology. CAJU is going to have Professor Susskind with us, online of course, in just over a week's time at a conference in which he will be delivering the feature address. And I urge everyone to log in because the proceedings promise to be more than a worthy supplement to the deliberations of this conference. COVID has created an enabling environment for us to appreciate fully the wisdom of Susskind's 30-year-old mantra that the court is not a place, it is a service. This appreciation results from a new mindset, one in which we consider our stakeholders as customers and ourselves as service providers. I would allow the professor to speak for himself, as he will next week. But before closing, I would just wish to indicate one of his ideas that resonated deeply with me. He advocates that we encourage the use of outcome thinking. People don't need or want doctors and nurses. They really want their health restored. People don't need architects and contractors. They want a fine edifice. They don't want judges and lawyers. They want justice. In other words, it behooves us to emphasize the importance of focusing on and attaining the desirable outcome rather than on the human expert or even the technological or process medium that we use currently to try to get us to that outcome. I thought that this approach of focusing on outcomes was especially prescient when the most important stock in trade of the administration of justice, the litmus test for measuring the value of courts, is the extent to which they enjoy public trust and confidence. Colleagues, there is so much to say and much more to do. Just imagine, I haven't even said a word yet about artificial intelligence and the prospect of its usage in the delivery of some justice services. But that is for another time. In conclusion, I wish to reiterate how pleased and extremely proud I am to see that Apex is so admirably fulfilling its role. Apex currently provides cutting-edge technology services for judicial institutions in 11 different English-speaking Caribbean states. And this provides a firm basis for all of these institutions and representatives of other legal and judicial bodies as well to collaborate on and coordinate our approaches to technological developments that will make a positive difference to the Caribbean justice sector. There is little substitute for investing in regional solidarity and a collective awareness of global trends, societal shifts, and their implications for judiciaries. I thank you so much for your attention.